Hello, everybody. Welcome to our webinar for today, Dealing with the Ongoing Uncertainty of COVID-19, Legal and Insurance Guidance. Today we have some experts. We have Sarah and John doing the legal, and we have Jim and Stacy doing the insurance questions. I'm going to have them introduce themselves. But first, we're going to go over the topics we're going to discuss for today. We're going to go over the COVID-19 authority, community common areas, openings, access decisions, and best practices, COVID-19 liability and risk, enforcement of CDC and government guidelines, dealing with dues, collections and violations during the COVID-19, and meetings and elections during this time. Sarah, can you tell us a little bit, can you tell the audience a little bit about yourself?
Yes, my name is Sarah Beltman. I am the principal at Gateway Law, STL, and I have been practicing representing community associations since 2006. Everything from collections to amendments and elections, etc. I am very involved in CAI. I've served on multiple committees, and I am a former board president. And currently I'm the chair of the membership committee.
Thanks, Sarah.
Thank you.
John.
Thank you, Kathy. My name is John Sanner. I'm with the law firm of Brinker and Doyen here in Clayton. And our firm is primarily devoted to civil defense work. We handle only civil cases on the defense side for a number of different insurance companies, self-insured companies. And I've been doing this the entire 30 years that I've been in practice. A lot of the work that I get for community associations comes through the insurance carriers, a number of insurers that write general liability coverage as well as directors and officers coverage. I've been a member of CAI for about 8 years now, and I really enjoy the opportunities and the people that you get to meet through CAI.
Thanks, John. Jim.
Hello, everyone. Can't wait to do this in person someday. I'm Jim Rubson, Senior Vice President at the Daniel and Henry Company. Our firm's been serving community associations. I believe we wrote our first policy in the early 50s for an HOA, and I'm just trying to carry on the torch. I've been an active member of CAI since 2007, former board president, and currently serve on the communications committee. And again, thank you all for attending. It says a lot about your commitment to the industry.
Thanks, Jim. Stacy.
I'm Stacy Sapienza from O'Connor Insurance, and we specialize in communities and insure over 500 in the metropolitan area. Important to me is education, helping the boards and the managers understand, and doing programs like this. I'm active in CAI. I'm on the trade show committee. I'm a commercial account manager at O'Connor Insurance. We also do all lines of commercial.
Great, thanks, Stacy. Now I'm going to ask Jim and Stacy and Sarah if you can all turn off your video and mute yourself, and we're going to start the presentation, guys. Brett is also going to be on later for Q&A. He's not on right now, but I think most people probably know Brett from Pool Management. He was on our last webinar, so he'll be on later. John, ultimately, who has the authority to say what we can and can't do during this COVID-19?
That is a very good question to begin this program with, because I'm sure everyone has experienced listening on radio or on TV about the lifting of restrictions. And sometimes it seems like you're hearing it from different sources, whether it's local versus state versus national. And a lot of times it can be very confusing as to whose instructions do we follow. And it really has fallen down to the local level pretty much from day one. The federal government has really supplied information through the CDC in terms of recommendations and guidelines on controlling the spread. But the president has really delegated this to the states and the governors in terms of restrictions. And beyond the state, you have the local governments, primarily counties, St. Louis County, St. Louis City, St. Charles County, and they are the ones that are providing specific instruction. The state maintains kind of a baseline through its orders of minimum thresholds that must be satisfied. The counties, however, have gone further and added additional restrictions, and they have been lifted a little more slowly than the state. And I'm talking about St. Louis County and St. Charles County. But Missouri has authority to control infectious disease through the Missouri Department of Health and Senior Services. And what you find there is, again, kind of the bare minimum that everybody has to follow. And then St. Louis County, St. Charles County adds on to that. And it's all controlled by Missouri statute, which basically says the state's responsible for establishing the minimum, but counties can go further just so long as the counties don't contradict what the state has issued in terms of stay home orders and things of that nature.
So John, if we have members that are calling like from the Kansas side, we would just advise them to look to see what the state of Kansas and what their individual counties are doing, correct?
Absolutely, yeah. And I find that when you go online and you know, just type in Jackson County or St. Louis County, you're going to find the COVID information readily accessible, and it will tell you specifically what they recommend in terms of safety.
Awesome. Next question. Who or what are the best resources to use to determine who has authority in different situations and in different counties or cities?
I think that was the one we just did, Kathy.
Oh, I'm sorry. I apologize. As a private entity with private ownership, can our HOAs just do what they want?
I guess the short answer to that is certainly probably not. Just because you may be a private entity doesn't mean that you can disregard the safety, health, and welfare of people who may be using your property. So I think it would be very unwise, I should say, to think that we can just do as we please. You cannot put, in this case, owners at risk, whether they're, because of the fact that they're not socially distancing, they're not wearing masks. So I wouldn't think that any homeowners association or condo association would go down the road of just opening up without any regard to safety. That really falls to the counties. And an example that I can give is there was a local gym in the St. Louis area that had several facilities. I think it was called the House of Pain. And they were defying the St. Louis County restriction on the closing of gyms. And they were getting cease and desist orders from St. Louis County to close the gym. They refused, disregarded those orders, and St. Louis County actually went to court, and they ended up in federal court, and the federal judge immediately ordered that those facilities be closed. And one of the arguments that the owners were making to the judge in federal court was the fact of, hey, Missouri has no prohibition on the opening of gyms. How is it that St. Louis County can enforce a restriction against gyms when gyms in other parts of the state might possibly be open and the state doesn't require it? So, you know, again, the state provides the basic threshold, but local government is entirely within their right, and it's in the Missouri statute that local governments can add additional safeguards. So you need to be careful on what you look at, because if you saw that Missouri didn't require any restrictions on the gyms opening, you might think that you're good to go. But St. Louis County, until just recently, was not allowing gyms to open.
Is there any other best practices for communities to be making smart decisions if they are opening their common areas and common spaces?
You know, again, there are a lot of resources out there, primarily online. You know, the basic phrase that you hear is keeping social distance. And if you look at the numerous regulations, recommendations, and guidelines that are put out by the local government, it all falls back to that basic premise of social distancing. And so I think that you start there, and then you add to that with wearing masks. The guidelines are just that, they're guidelines. We see a lot of people walking around with masks on their face. And as I go to different facilities, whether it's the grocery store or over the weekend, I went to a local farmer's market. And at the farmer's market, they characterize the use of masks as mandatory. Whereas you go right down the street to a grocery store and it says preferred, or it says recommended. So business owners are kind of making their own decisions on how to word things and how to enforce things. But I think the best practices starts with the basic tenet that you're there, these rules are there to protect the safety and welfare, in this case, of owners and guests, and you must socially distance yourself from others.
If we have decided to reopen our facilities, what precautions, anything else we should take to limit our risk and liability if we decide to open like clubhouses or tennis courts, things like that?
Well, before any such decision is made, I think that trustees, directors need to be very well informed of what the restrictions are, what the guidelines are. If you're going to reopen a facility, you need to know what is going to be expected from you. So before making any decision, I think that it's wise for the board members to review whatever the local regulations and guidelines might be, whether it's St. Louis City, St. Louis County, St. Charles County. So know what those guidelines are. And then once you make a decision, I think that it's important to communicate with the community, communicate with the owners on your decision and how you reach that decision. I think communication is very important because people may have expectations that when the pool opens, it's just like last year and we're all going to have a great time. But there will be restrictions. And finally, I think you need to implement those restrictions, whether it's signage, reminding people about 6 feet distance, signage about sanitizing, what you can use, what you can't do, whether it's a swimming pool or a gym or a clubhouse. So I think you need to go through multiple steps, and that will reduce the risk of liability. When I get a new case in, the first thing I want to do is establish what the standard of care is, which is basically the guidelines. And beyond that, what did the association do to comply with those guidelines, and what did they not do? A lot of times what you can and cannot do is really controlled by the property. And if it's, physically impossible to maintain a 6-foot distance because the pool deck won't really allow it, then you need to keep the numbers down in terms of who can be at the facility at any given time. You may have to restrict access to the clubhouse or to the gym or to the tennis court, whatever it might be.
Okay, thanks, John. What are the benefits if a community association decides not to open their facilities?
You know, that's an interesting question, because I recently had a case that I'm working on with Sarah as well. She represents this HOA. And let me put it this way. I'd much rather be on the side where the client did not open than the side of the association that did open and didn't take all the necessary precautions. The bottom line is, you're doing this for the safety and welfare of your owners. They may not like it. They may feel like you're infringing upon their rights. They may feel like they paid for the operation of the facility through their assessments. So you're going to get a lot of pushback. I shouldn't say a lot, but you will get some pushback from owners who want to open up. But I think that the board is well within its discretion. And if you go to the indentures, many of the indentures, and I've looked up a few of them, basically state that the board is responsible for operating and maintaining the common areas for the safety, health, and welfare of the owners. So if they don't do what they should do in opening up, they could very well be subjecting themselves to potential liability because of their obligation as set forth in the declaration or indentures.
Thanks, John. As you defend a community association for not opening, what would you like to see in your bag of defense tricks?
You know, I wish I had a bag of defense tricks. That would be pretty good. Maybe some of my opposing counsel has accused me of having some defense tricks, but seriously, what you want to do again is examine early on, what did the board do before making its decision? How informed were they? Did they go online and take advantage of the resources that you can find on the COVID subject? Did they talk to other communities about what they were doing and find out why they were doing what they were doing? It's all about, making sure that you've taken advantage of the resources that are out there. And if you can basically substantiate your decision to not open, I think that you're not setting yourself up to potential liability. On the other side, if the board just decides to open without regard to what these guidelines are, they could end up in a lot of hot water, so to speak, if somebody would become ill.
If a community manager or a board member becomes aware of a COVID-19 case in their community, is there any actions they should take?
Well, I certainly think that the individual himself or herself should be prohibited from, what they should do is self-quarantine. I mean, I think everybody understands that if you've been diagnosed, you need to self-quarantine for 14 days or longer. But in a situation like this with an HOA or a condo association, I think that what's important is to keep a record of who is using what facility at what point in time, whether it's a reservation system where people have to reserve a time, let's say between 1 o'clock and 3 p.m., or whether there's a sign-in sheet that people have. Because if somebody does get sick and they're pointing to, let's say, the pool, for example, and we have a record of everybody that was there at the same time that this individual was, I think that the board has an obligation to notify all of those persons that there was somebody who tested positive who was at the pool on this date at this particular time. So I think that it is important that the board take affirmative action. They call it tracing. And I think that you can do that. Same thing with a gym, or let's say there is some group that's in the clubhouse for some reason. You need the names of those people who are in there at any given point in time. So if there is an unfortunate situation of somebody testing positive, you can go back and identify those people and notify them of the fact that this happened. I think you're really under an obligation to do that.
So sign-in sheets are really important, especially right now.
Sign-in sheets are important just so long as you sanitize that pen after each use.
That's funny. Yes, yes, absolutely. Okay, we're going to move on to insurance. So John, if you can turn off your video and mute yourself, and Stacy and Jim, if you guys can come back on. Great, guys. So we're going to move on to liability and risk. What risk do our communities take on if they decide to open up community facilities and common spaces? I don't know who's going to take it, but I'll let you guys decide.
I can start. This is a really good question that a lot of our associations are concerned with. There are risks they take on when they decide to open up the facility. Will there be insurance coverage? That's a big question we get asked. And the answer is we don't know. We don't know what the insurance companies are going to say. But insurance companies were never designed to pay for pandemic losses. These losses are immeasurable and they cannot be appropriately charged for. If insurance companies were to pay these type of losses, it would put the solvency of the companies at risk. So they have implemented exclusions in their policy to help avoid this. In your general liability, you have an exclusion for expected or intended injury. If the board opens up a facility, they could expect someone to contract the virus at the facility. This would be an excluded loss. You know, if not for that exclusion, there's also in many policies, there's an exclusion for communicable disease losses. So both of those would prevent the association from turning to the insurance carrier for remedy. And if there's no insurance carrier to turn to, if there's no covered claim, there's also no defense for the allegations, which would present a financial risk. If there's no defense under the insurance carrier, the association would have to bear the cost of the defense out of their association funds. And can they do that? Have they adequately planned for something like that? I don't know. It just depends. Jim, what do you think?
No, I agree. There is a lot of uncertainty right now in the insurance industry regarding coverage. You know, in my opinion, we're probably going to see these claims potentially defended under what's called a reservation of rights, meaning the insurance company might provide some initial defense, assuming there's no communicable disease exclusion. If there's a communicable disease exclusion, you're probably on your own. So you do want to ask your insurance professional if that exclusion is on your general liability policy. And if it isn't there now when it renews, if it renews between now and the end of the year, it's probably going to be there when your policy renews. And we're seeing a lot of that. But let's say you don't have that exclusion. The insurance company might defend you, and then while they analyze coverage under this reservation of rights, and the coverage attorneys within the insurance companies might at that time say, nah, we are going to point to the expected injury exclusion, or maybe another exclusion on the policy. We've even heard pollution liability. There's often virus and bacteria exclusions. So, you know, at this time, I don't think any insurance professional can stand here and say, yes, you have coverage. There's too many unknowns. And therefore, you know, again, as Stacy said, the financial risk is there, given that you cannot necessarily rely on your insurance policies to defend you in a lawsuit.
I would just add that maybe if you are in doubt, if there are allegations, talk to your insurance professionals, turn in the claim, and let the insurance carrier make the determination.
That's good. Is there a way that a community association, HOA or condo can limit their liability? Is there anything that they can do?
The liability cannot be eliminated, but they can take actions to help provide a good defense in the event that allegations are brought against them. They're making decisions to protect the safety and well-being of the residents. So yes, they could be liable for those decisions. Follow the guidelines, to a T, and do everything they can to try to prevent a loss.
I think pointing to what John said in the previous slides, if the board can demonstrate and the manager can demonstrate that they took many steps to protect the safety and well-being of the members of their community, that limits your liability. And you can get sued for anything at any time by anyone, but they have to prove it. And they have to prove your negligence. And, I don't mean to put on an attorney hat because I'm not an attorney, but, when we see insurance claims and we see a board that has executed their duties, to the letter of the law and also in accordance with their governing documents, to state and local laws, that makes defense a lot easier. And I would point to CAI, and I know this has been discussed many times, does have a great resource, and I'm looking at the name of it, bear with me. It's called Healthy Communities. They're updating it very regularly. If you could go on CAI's national website, I would really recommend all property managers and board members download that document and have it with you as you discuss reopening common areas and amenities. And then also have the local county or municipality regulations in front of you as well as you go through those considerations.
We've been sharing that document, so thanks for shouting it out, Jim. I will continue if any managers that are listening or any members, if they want access to that, I'll be happy to send it to you too. I'm sorry,
John
Stacy.
said earlier, communication is huge. Have a written plan, communicate it with the owners, such as the letter that's available through CAI. Set their expectations.
Absolutely. Moving on to the next slide. What liabilities do the board members individually have?
Sure. So board members are running a business. They're the managers of that business. It doesn't always feel that way because they're in a volunteer role and sometimes they're not even from the business world. It just seems like a neighborly thing to do. But at the end of the day, board members managing a business are subject to liability on an individual level. This is why you really need to have a very strong directors and officers liability policy. Make sure it has non-monetary coverages, non-monetary damages coverage. If it doesn't, get a new policy. Non-monetary damages account for the majority of D&O claims. As an example, let's say the board makes a decision not to open the common areas, the pool, the tennis courts, and a group of rogue members bands together and says, well, we're not going to pay our dues and we're going to sue you because you don't have the authority to shut down this community. That is a non-monetary type claim. Now, the dues themselves might be monetary, but the challenge to the board authority itself has no monetary value to it in typically in how that lawsuit's going to be written. And therefore, you want to make sure you have strong D&O coverage so that the board can make decisions on behalf of their neighbors without fear of repercussions or even putting their personal assets on the line. Also, most community associations in their governing documents do indemnify board members and protect them against any claims against them individually. So maybe the case that if there is a lawsuit against individual board members, and let's say you have a bad D&O policy, the association may still be legally obligated to defend those board members as individuals via the governing documents. And again, defense, even if you're right, defense can be very expensive. And as Stacy pointed out earlier, that can present big financial risk for the community.
Is the liability different if a HOA is incorporated versus not incorporated?
I might ask one of the attorneys to jump in on this. My non-legal opinion is no. I do believe there are some of the nonprofit, corporation laws in Missouri that may come into play versus for those that are incorporated versus those that aren't. John or Sarah, would you mind unmuting and jumping in on this one? Did we lose him?
Oh, here comes John.
All right.
Yeah, with regard to incorporation versus not incorporated, there's a law out there that's generally known as the business judgment rule, and that basically protects a director from liability if his decision was made in good faith, and conversely, if there's evidence that there was bad faith, self-motivated action taken by a director, he or she could be subject to liability and get no protection from the business judgment rule. Obviously, when you're incorporated, one of the reasons that you incorporate is to have that separate entity there. The HOA is a legal entity that can sue and be sued. And I think the primary difference here is potentially that all of the owners within an association could subject themselves to liability if they are not incorporated. Because again, the HOA is the owners. And if there is no corporation, that liability could fall to all of the owners, the directors and all of the owners because of their status of not being incorporated.
John, does the business judgment rule also apply to trusteeships?
That's a good question. I think it really hinges on whether or not there's a corporation involved. The authority that I've read for that rule, and we've used it in defending cases, the plaintiff's lawyers are bringing in directors more and more frequently. And I think that they're doing it kind of as a pressure point, because it's one thing to be a director when the corporation is sued. It's a whole nother thing when your name shows up on a petition. And the first thing that we try to do is extract those directors from the litigation, whether it's under the declaration, as Jim indicated earlier, in many instances, the HOA must indemnify those directors on claims brought against them. But I think that with the business judgment rule, it really does have to involve a corporated entity.
Great, thanks, John. Last slide for insurance. Do the community managers or management companies have any liability for their decisions for the community they are a part of or that they manage?
This is also a really good question that we get. Management companies do have liability as an agent for the association, but they can help limit that liability by making decisions at the direction of the board, taking their direction from the board. We often do see management companies named in the litigation. They can limit their liability the other ways the association can by following the guidelines and researching what the best practices are, following the most stringent guidelines, setting the expectations to owners.
Jim, do you have anything you want to add to that?
Sure. Yeah. I mean, most management company contracts have some pretty strong indemnification language. So a lot of times with our association clients, when a claim arises, maybe a manager made a decision, but at the same time, usually it was at the behest of the board. And then you have this management agreement that indemnifies the manager against any and all claims. In addition to that, from an insurance standpoint, property managers hold a special position in the insurance world. Often they're automatically included as additional insured on a general liability policy. A lot of times on D&O policies, at least the ones that we in O'Connor write, the property manager isn't insured under the board's policy. So, you know, if the managers do get pulled into these claims, we often see the association's policies have to pick up coverage, assuming there is coverage. Again, going back to a couple slides, if there's no coverage, the association may have to defend that manager on their own dime. So again, as we've been saying, following all these guidelines is critical, listening and consulting with the professionals of the association, your attorney, your insurance professional.
Absolutely.
I think if I could add one thing about limiting liability for the association, the manager, the board, the best way to limit the liability is to not open the facility. If you can't comply with the guidelines, you know, and you don't want to take on the financial risk, don't open the facility.
Okay. Thank you guys for answering the insurance questions. So I'm going to ask Stacy and Jim to both mute yourself and turn off your video. And Sarah, you're up. Hey, Sarah.
Hi.
We're going to start enforcement of the CDC and government guidelines. Are community associations allowed to legally enforce the CDC and other government rules and regulations regarding COVID-19?
Well, the community association is authorized to promulgate and enforce rules pertaining to the safety, health, and welfare of the community. And in adopting such policies of their own that rely on the guidance of the CDC and other local regulations, then they are creating that own rule or policy for their own community. And then, yes, of course, they will be authorized to enforce such rules.
What's the best way we can enforce those rules and regulations?
The best way is the same way you enforce any other rules and regulations within the community, based on the authority in your documents and the processes adopted by the board for doing so.
Okay. Can the local government of health agencies close down our facilities or common spaces in our HOAs or condos if they're not following the rules and guidelines?
So many of the jurisdictions are providing guidelines only and not necessarily orders or mandates. So in those situations, they wouldn't have any order to look to in order to enforce. There wouldn't be an order to enforce. However, the guidelines should be followed by the board in order to comply with any local ordinance that is adopted. And your guidelines should also limit the liability of the association, and they should minimize the risk of a resident or a guest becoming ill. That's your board duty. If the board finds that enforcement of any of these guidelines that are best practice, that it's not feasible to enforce them, then the board should regroup and reevaluate, modifying guidelines, modifying rules in order to have a operational guidelines that they can enforce and that still protect the safety, health, and welfare of the community. And like Stacy just said, if enforcing the guidelines to a level that actually protects the community, that A, complies with any local ordinance that limits the liability of the association and minimizes the risk of someone getting ill. If the association is incapable of operating at that level, then maybe they need to not open the clubhouse, not open the on-site gym, restrict the amenities so that they're not in a position where they're exposing themselves in those 3 ways.
Gotcha. Let's move on to dues, collections, and violations. Are board members are board members under any requirements that would prevent them from collecting dues during these challenging times?
No, the biggest obstacle right now is that not all of the courts are issuing summons on new cases. So if a board is dealing with delinquent owners, I would encourage them to contact their attorney, have a demand letter sent out, as well as a lien recorded in order to protect their interest, at least take those preliminary steps. And in my experience, I'm getting a very, very good response to demand letters that are going out and liens. Even though the courts aren't open, the owners, once they get that attorney letter, they're wanting to either pay it up or work something out. So I would encourage boards to continue their collection processes to the extent that they used to. And if they want to take certain considerations, do it case by case and community by community. I don't think there's any blanket advice on that.
Do you recommend that they, I'm sorry.
I kind of moved into the next question.
Sounds good.
So, but to touch on the rest of that second question, if you are offering grace periods or something like that, I would encourage boards and managers to, number one, get any arrangement with an owner in writing, and to avoid any long-term or otherwise complicated arrangements without first consulting your collection attorney. Because, for example, the condominium lien, that caps at 3 years. And if you have an agreement with an owner that they're gonna just pay an extra $10 a month into infinity, well, you're putting yourself at risk of not being able to ever collect that money. So just consult your attorney. They'll make sure that you get whatever you need in writing, so that later when the excuse extends for months and months and months, we have something in writing, like, this is what you agreed to and you're not complying. So yes, that is why now we are taking attorney action against you, so that it's definite.
What about homeowners that aren't maintaining their property or homes? Are you advising that we do fines right now, or offer grace periods, or what is your thought on that?
I think that same business as usual, and anytime there's a fine, best practice is a notice of the violation, right? So you're notifying the owner, hey, this is a problem, whether it's mowing their lawn, whatever it is. You notify them of the violation and provide them an opportunity to cure. And if they don't, they have an opportunity to be heard, to explain their situation, to ask for some type of consideration. And after that opportunity to be heard, the board makes a decision and either works with that owner or imposes a fine, or, you know, I think that's a standard to stick by. And depending on what the owner is asking the board to consider, that is, you know, that's case by case, like any other violation. It might not be COVID related at all. So, you know, surely they can mow their grass, right? I mean, unless they're ill, you know, so it's case by case.
Sure. Okay. Sounds good. Let's move on to meetings and elections. I've been getting lots of emails about this topic. We are going to cover this topic later on in July, but I wanted to kind of hit on it today. What should board members consider to determine whether it's safe to resume having, you know, board meetings or annual meetings?
Well, I think that I would start with what the recommendations are. If we are still receiving recommendations to not meet in groups of more than 10 individuals, why would we invite 300 homeowners to a closed space, right? So that, I mean, that and the comfort level of the board members themselves, the level of vulnerability of the board members themselves, and consult your attorney to see to what extent do our documents maybe allow us to do things a little bit differently. Can we hold our annual meeting via Zoom? Can we have our election with a mail-in ballot instead of all crowding in a room and casting a ballot? So every community might be a little bit different in what are they wanting to do, but also what do their documents and or the Nonprofit Corporation Act might provide them leeway. But the Nonprofit Corporation Act also might lock them into only doing things the way that their documents specifically state. So that is going to be a case by case for each community and for each situation that they're encountering. So I think it's very important that as we're all going forward during these uncertain times, that the associations, the boards, the managers, just continue to consult your experts to make sure that you are doing things within your authority. And when you think you might not have authority, there might be a way around it. And these guidelines and the courts and everything else, they are changing. They're changing so frequently. It's difficult to keep up.
Fluid situation right now, yes.
It is. For example, St. Louis County, for weeks and weeks and weeks, Sam Page was adamant the pools are not opening. The pools are not opening. The pools are not opening. And then one morning I hear him on a press conference saying we're opening the pools. So, you know, it's kind of day by day.
It's changing as per minute sometimes.
Right.
I think we're done with the presentation. I think we're going to open it up to Q&A here real quick. So can all of our panelists come back on and unmute themselves? And we have Patrick and Jennifer that are fielding the questions that are coming through. So if you are attending this webinar and you have a question, you can go down to the bottom under the Q&A and post a question for the panel. So Patrick or Jennifer, do you guys have any questions for us?
Yes, I've got a few questions. They're very similar in scope, so I will not be redundant. These questions are based on D&O policy and coverages and things like that. So this is from an anonymous attendee. If a board members are named individually on a lawsuit alleging that an owner contracted that disease at the community association pool, won't the D&O policy cover the board members?
I can take this one. The D&O policy has an exclusion for bodily injury, including disease. And if there's no coverage under the D&O policy, there's no defense under the D&O policy either, again, leaving the association to bear the cost of the defense.
Yeah, and even if it was kicked over to the general liability policy, which, you know, if we got that claim, we would probably submit it under the general liability policy. There is protection for individual board members as members of the association if they're named in addition to the association. So, but then again, is there coverage? So we keep going back to that. Is there even going to be coverage in the first place? And that is a big question mark. I don't think we're going to know for some time. I think the courts are probably going to look at coverage issues, and it might be a couple of years before we have any clarity, if we get it at all.
So I would like to just add to that. So if the insurance policy is rejecting coverage and there's no insurance covered defense, oftentimes there is usually the indemnification clause within the indenture or declaration, which would allow the association to cover the cost of that individually named board member's defense. So depending on, so long as that board member was acting within the scope of being a board member and conducting association business, and there's no nefarious claim, more than likely the association would be authorized to cover the expense of that defense. However, that is money out of pocket for the association. So it's still a financial risk.
All right. The next question kind of goes along that same lines of liability. Cannot a board get a liability waiver signed by the owners that want to utilize that common facility? Maybe make a promise not to sue the board? Something like that. Is that viable?
John, why don't you take this?
Yeah, we see it, what we call non-liability waivers in a lot of different scenarios. And if you're going to do one, you have to be very careful how you word it. And it's got to basically specifically identify claims arising from the HOA's express negligence. You really can't have one of those waivers that call for no liability in cases of gross negligence or intentional acts or things like that. It's usually simple negligence that those waivers are intended to cover. But again, and I don't have time to get into all the specific language, but you really have got to be very tight with the waiver, and usually it's a page long, and then you get down to the question of, well, did the owner or the signator to that waiver even understand what it said? Because it's a lot of legalese. So you can do it, and it's largely a deterrent to people bringing claims down the road. But whether it holds up under a court scrutiny it just depends on how it's worded.
John, would those waivers extend to those who didn't sign it, like a spouse or the signatory's children?
Well, what I've seen, Jim, is a single form being used, and then if there are children, obviously they can't sign for themselves, but everybody in that group, their name and age will appear on that form, and then the head of the household will generally sign off on. I wouldn't suspect that at this stage that pools are even allowing guests to come in. It's probably just owners and immediate family members. But I do think that a single waiver can be used for multiple people.
Okay, this is from Michelle Olachek. If the governing documents do not permit mail-in ballots, is it necessary to have a board resolution drawn up to give the board the authority to conduct their elections by mail? Then, at a later date, call the annual meeting in person when the COVID restrictions are lifted?
Well, without knowing the particulars, I can't answer that entirely, but that sounds like it very well may be a viable solution to the current problem. So I would encourage you to contact legal counsel and make sure that that would work in that situation. It sounds like it may.
Okay, last question that we have right now. If you open the pool and a management company employee is the pool lifeguard or pool operator, who, if anyone, is liable if he or she contracts the virus? Same question for an association volunteer doing his job. Good question.
I'll jump in quickly. So this is actually a workers' compensation type question. And this is something we anticipate a lot of COVID-related workers' compensation claims across all industries. I think the pool management company at the end of the day would need to rely on their work comp policy. And hopefully that'll be the sole remedy. The attorneys might be able to answer this better. I don't know if that employee will have any sort of case against the association itself. However, it's a lot different question about an association volunteer, a non-compensated volunteer. Often there's not going to be coverage for that volunteer for bodily injury, and if it's considered a workers' compensation type injury, an illness contracted while working on behalf of the association, it could be very well excluded from the workers' compensation policy. From the general liability policy. There are workers' compensation policies out there that will cover volunteers if they're working within the scope of the board's authority, and I won't get into all of that, but that is a concern. If you do have volunteers, there are some work comp policies out there that maybe you should look into.
I agree with Jim. For your volunteers, protect them with a specific workers' compensation policy designed for communities. So contact your insurance professional to obtain one of those. They're usually very minimal cost.
Is there any more questions, Patrick?
Nope, that's all we have.
Okay. Then I'd like to thank Sarah, John, and Jim, and Stacy, and Patrick for helping with the questions. Thank you guys for presenting and being here today. Just wanted to let the attendees know that we would encourage you to join us for our next webinar, which is scheduled for Wednesday, July 1st at 11 a.m. It's meetings, elections, and assessments during COVID-19. Our panelists of experts are Jeff from CIT Bank, Stephen Davis from Carmody McDonald, and Elia Ellis from Elia Ellis LLC. We encourage you guys to look for emails to sign up for this next webinar. And we hope you guys have a nice summer and stay safe. Thank you.
Thank you.
Thank you, Kathy.
Thanks, everyone.
Thank everyone.